Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzelli & Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by DocketWise, an all-in-one immigration forms and case management solution trusted by thousands of immigration lawyers across the U.S. I really like DocketWise. It makes immigration applications easy by allowing the clients to provide information through simple online questionnaires that are shareable by text or email and available in multiple languages. Not only that, DocketWise provides a comprehensive group of case management features, including invoicing and calendaring, secure messaging, task management, and a lot more. You can learn all about DocketWise and receive a 10% discount on your subscription by heading to docketwise.com/immigration-review, so they know we sent you. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. Many cases this week, and they were a lot of fun, and a few of them were quite consequential. Won't you join me? I'm actually coming in with my travel mic from a hotel in Seattle, where we ended the year with a big win for a longtime KKTP client. Everyone is happy. This entire month, in fact, has helped remind me why we do what we do. But as my wife reminded me just yesterday, there is no rest for the wicked, and no one mourns the wicked. So here are your cases. Kicking it off with Espinoza-Ochoa v. Garland, published by the First Circuit on December 27, 2023. This case is about particular social groups and nexus. Mr. Espinoza-Ochoa is from Guatemala. In 2004, he acquired a corn and cattle farm in that country, where he worked with his wife and children. One day he realized that 2 cows had been stolen. He told police, who promised to investigate, but they did nothing. So he and some friends went to investigate. He found his cows some days later and called the police, who said that they'd be by shortly to resolve the situation. While he waited, he received a call from an unknown caller asking for his location, which Mr. Espinoza-Ochoa believed might be a threat. Police arrived hours later. Turns out the property owner was a gang leader and police really didn't want to intervene, but community pressure forced their hand, and they arrested the gang leader for stealing the cows. Quote, amid the commotion, a child ran up to the suspect, telling him, "The boss is saying you don't have to say anything, he's going to take you out of jail." End quote. That's in fact what occurred, and Mr. Espinoza-Ochoa received multiple threats thereafter. Indeed, even, quote, during Mr. Espinoza-Ochoa's questioning at the police station, an officer told him that the suspect was the officer's brother and warned Mr. Espinoza-Ochoa to be careful what you were doing, end quote. The gang left threatening notes. Mr. Espinoza-Ochoa took these threats seriously because other farmers in the area had been killed for similar things. Mr. Espinoza-Ochoa eventually fled to his father's town an hour away, but the gang got him there too, as they did at his sister's house elsewhere, continued threats. He fled a few more times, but kept receiving gang threats and so eventually fled to the United States in 2016. He passed his credible fear interview and was deemed credible by an immigration judge, but was denied relief. The IJ believed his particular social group overly circular, as the IJ believed it defined by the risk of persecution itself. The proffered group, quote, land-owning farmer who was persecuted for simply holding the position of farmer and owning a farm by both the police and gangs in concert, end quote. Not gonna lie, it's not the best articulated group I've ever heard, but then again, who knows if he even had an attorney before the IJ or what was actually argued. Nor did the IJ think that this was the reason for the harm anyway. Rather, the immigration judge saw this simply as an example of criminal activity by a gang, which, while unfortunate, doesn't get a non-citizen asylum. In this vein, to the IJ, quote, the threats were driven by revenge for reporting the gang to the police, not by a desire to harm landowning farmers, end quote. The BIA affirmed. The First Circuit did not. Particular social groups must be comprised of individuals that share an immutable characteristic, defined with particularity, and be socially distinct in the society in question. Here's where the decision gets interesting to me, though. Quote, the circularity rule resides in the social distinction requirement and reflects that an eligible particular social group must be perceived as a group by society, not merely by its persecutors, end quote. Restated, it's usually the case that a particular social group isn't socially distinct simply because the group is persecuted. That's circular to many courts. Fair enough. But then the reasoning goes, if a society deems a group distinct if or when they become subject of continuing risk of persecution, well, that wouldn't be impermissibly circular, even if the initial impetus to defining the group involved persecutory or criminal conduct from the persecutor. Or as the First Circuit says it, quote, the shared trait of persecution does not disqualify an otherwise valid social group, end quote. Quoting directly from the BIA in the seminal decision matter of MEVG, by the way, harm suffered can be a relevant factor for a proffered particular social group, if, of course, other evidence supports its distinction in the country in question. In fact, quote, in some circumstances, the act of persecution may be the catalyst that causes the society to distinguish the group and consider it distinct, end quote. Well put. All of this requires case-by-case analysis and is fact-specific, explained the First Circuit. To be very clear, it is not, as often is assumed the case, quote, a rule that any reference to harm in the formulation of a particular social group is fatal, end quote. Particular social groups can include the phrase, quote, was persecuted, end quote, in the definition. It is not always the case that, quote, a sufficiently distinct social group must exist independent of the persecution claimed to have been suffered, end quote. There is no, quote, categorical bar to any social group that references harm, end quote. How many different ways can I say it? Well, I'm saying it like this because, honestly, many courts have cases that seem to hold otherwise. But to the First Circuit, those decisions aren't nuanced enough. When you're reviewing it at this nuanced level, the First Circuit believes that this rule, is the law in every circuit. Cite to footnote 6 in other circuits. Not only that, while it is the case that land ownership does not automatically confer a particular social group status, usually at least, quote, it is well established that landowners may have the necessary social distinction to qualify as a particular social group, end quote. Citing many a circuit and the BIA for that quote, as you should too. Anyway, it meant to the First Circuit here that the BIA and presumably the IJ need to conduct further analysis on social distinction and can't simply rely on the purported circularity of the words used to describe the group. Particularly as Mr. Espinoza-Ochoa provided additional country condition evidence showing just how distinct landowners are in Guatemala, both from regular people and under Guatemalan law. Speaking of Mr. Espinoza-Ochoa, remember him? Haven't actually brought him up in a minute. All of this is even more important because if it's a viable particular social group, the First Circuit believed that his membership in it was likely a central reason for the harm he suffered. That's nexus. And to succeed on nexus, an applicant, quote, need not prove that a protected ground was the most important reason that the gang and the police persecuted him, end quote. Just one of other central reasons will do. Yes, the particular social group can't be incidental, tangential, superficial, or subordinate to another reason for the harm, but there can be many motives. All you need is one, to misquote John Lennon. What you can't just do in analyzing it, as the IJ apparently did here, is find that it was simply, quote, generalized criminal activity, which would not generally be a basis for asylum, suggesting the gang's motivation was greed and wealth, end quote. The IJ needed to dig deeper. And even if correct, quote, the agency's conclusion that Mr. Espinoza-Ochoa's persecution was motivated by the greedy desire to obtain his valuable property or by revenge does not itself exclude the possibility that his ownership of a farm was at least one of the central reasons for his persecution, end quote. Initial motives that are personal or criminal in nature can transform into a cognizable reason for asylum purposes and satisfy nexus. Or at least, at a minimum, can be present alongside another cognizable central reason for the persecution suffered or feared and still succeed. Really, this entire decision is gold for non-citizen asylum seekers. And, although the First Circuit is sending it back for further analysis, it believes that the, quote, IJ's own factual findings concluded that the gangs specifically targeted landowning farmers and stole their livestock to pressure them to give up their land, end quote, which to the First Circuit likely satisfies nexus. If you haven't gathered it yet, Mr. Espinoza-Ochoa succeeded in a bomber of a decision, meaning, congratulations Greg Olin for petitioner. And even though I've given you many excellent quotes already, there's also this. Gonna leave this here for your future cases without further comment. Quote, Salvadoran women who are unable to leave their domestic relationships, where they have children in common with their partners, is a group that appears to be defined in part by the alleged harm. But if those women's inability to leave their relationships stems from circumstances independent of the alleged harm, for example, legal constraints on divorce, then the group would not be circular because the inability to leave does not refer to harm at all, end quote. And that is Espinoza-Ochoa v. Garland. So how about that? Let's eat our vegetables a bit with the 8th Circuit before returning to some non-citizen friendly from the 9th. First is Pascual-Miguel v. Garland, published by the 8th Circuit on December 27th, 2023. This case is about many a thing, but let's call it nexus. Mr. Pascual-Miguel and his minor daughter are from Guatemala and entered the United States without inspection or admission. Seemingly discovered shortly thereafter, they were placed in removal proceedings where they applied for asylum and related relief and protection. The claim, you ask? Well, it was based on the fact that Mr. Pascual-Miguel's home in Guatemala was burned down while he was in Mexico. But he told the immigration judge that he had no idea why it was burned down. In fact, this appeared to be a through line of the case before the IJ. No one knew why, although Mr. Pascual-Miguel speculated that it related to jealousy over an inheritance. The IJ denied everything and the BIA affirmed. Importantly, the IJ denied asylum because the application was untimely, having been filed over a year after Mr. Pascual-Miguel entered the United States, although the IJ and the BIA must have denied withholding of removal on the merits, which would almost surely apply to the merits of the asylum application as well. After the BIA affirmed, Mr. Pascual-Miguel filed 2 motions to reopen with the BIA. So we're already in rough procedural territory. The first of those motions was based on ineffective assistance of counsel. The second motion to reopen was based on Mr. Pascual-Miguel's asserted membership in the Mendez Rojas Class Action. If true, that would make Mr. Pascual-Miguel's otherwise untimely asylum application timely. The BIA denied both motions. And that's what seems to be on petition for review to the 8th Circuit now, the denial of those motions to reopen, rather than the substance of the IJ and the BIA's denial of asylum and related relief and protection. I guess? Unsure, because actually the 8th Circuit is talking directly about the IJ and BIA's decision to deny withholding of removal and CAT first. Maybe the 8th Circuit is doing so under the guise of a prejudice showing for ineffective assistance of counsel motions to reopen? I don't know. But that would make sense, right? Because if there's no way that Mr. Pascual-Miguel warrants withholding or CAT anyway, it kind of doesn't matter how ineffective his counsel was. Under the law of reopening, anyway. Noting that, quote, motive is critical, end quote, for withholding of removal, the Eighth Circuit saw no error in the IJ and BIA's denial. Mr. Pascual-Miguel didn't know who or why his home was burned down, and even his speculation about the inheritance dispute motive equated to, quote, general criminal intent, end quote, which the Eighth Circuit explained, quote, is not a persecutory motive, end quote, under asylum and withholding of removal law. Similarly with Convention Against Torture Protection. While a nexus to a protected ground isn't required, the fact that Mr. Pascual-Miguel didn't really know much of anything relating to his sole claim to fear torture made it such that, quote, any failure of the IJ to further develop the record is immaterial, end quote. Didn't matter to the Eighth Circuit what Guatemala country condition evidence shows where the facts specific to Mr. Pascual-Miguel's fears are so unclear. Moving on a bit, the failure to have a plausible claim to relief and protection, as the Eighth Circuit just held, is going to probably tank an ineffective assistance of counsel-based motion to reopen. And so yes, while Mr. Pascual-Miguel's, quote, attorney's performance was presumptively deficient based on discipline by the Missouri Supreme Court, end quote, so, eek, quote, Mr. Pascual-Miguel's lack of knowledge as to who was burning down his house foreclosed any reasonable likelihood of a persecutory motive, end quote. Restated, the Eighth Circuit does not believe that the BIA panel was comprised merely of illogical talking heads. And yes, that is indeed a very bad joke. Turning to the Mendez Rojas class action, the first time this time bomb of an issue has reached a precedential circuit decision, I believe. Pursuant to the Mendez Rojas class action, quote, asylum petitioners may file beyond the statutory deadline if they were not initially informed of it and expressed a fear of returning to their country of origin, end quote. Important class action. I could be wrong, but I think there's also a time limit on when the non-citizens needed to enter the U.S. to be included in the class settlement, and when they needed to assert their membership. Unsure, I advised looking it up. But in any event here, not only does it appear that Mr. Pascual-Miguel may not have provided enough detail in his affidavit to assert class membership, but it doesn't matter to the Eighth Circuit. As he doesn't warrant withholding of removal on the merits, he wouldn't be able to establish asylum eligibility even if his application was deemed timely because of Mendez Rojas. And for that reason, the Eighth Circuit affirmed all of the BIA's denials and dismissals, and Mr. Pascual-Miguel and his daughter did not succeed. And that is Pascual-Miguel v. Garland. Next is Essel v. Garland, published by the Eighth Circuit on December 28, 2023. This case is about sua sponte motions to reopen. Mr. Essel is from Ghana. He came to the United States as a student and 5 years later obtained conditional LPR status based on his marriage to a U.S. citizen. I guess USCIS also eventually removed the condition to his LPR status because he eventually applied to naturalize. Or maybe not. Sometimes the petitions to remove the condition are so backed up with USCIS that they end up traveling alongside the naturalization application itself, and then everything is decided all at once. Such is the wild world of USCIS delay. The Eighth Circuit reports that USCIS eventually denied the naturalization. Looks like Mr. Essel applied to naturalize when he became eligible after only 3 years of marriage. But that special rule permitting naturalization after 3 years of LPR status rather than 5 years as is normal only applies if the LPR is residing with the petitioning spouse. And apparently Mr. Essel and his wife were not during the 3 years preceding the application to naturalize. They were living in different states. And apparently Mr. Essel wasn't truthful about that during his naturalization interview, so USCIS also held that he lacked the required good moral character to naturalize. Then, the couple divorced. And then, DHS charged Mr. Essel as removable as having obtained his LPR status through fraud. So it really went downhill fast for Mr. Essel. Make sure you have all your ducks in a row before you apply to naturalize. An immigration judge ultimately deemed Mr. Essel not credible, found him removable as charged, and ordered him removed to Ghana. Now, there's of course a waiver for all of this, assuming fraud was committed, INA Section 237A1H. But it appears that by this time, Mr. Essel didn't have the LPR or U.S. citizen spouse, parent, or child required to apply for that waiver. Just noting. The BIA affirmed. 3 weeks later, reports the Eighth Circuit, Mr. Essel married another woman named Pearl. Pearl filed a Form I-130 petition for Mr. Essel. At first, USCIS intended to deny it by relying on INA Section 204C. USCIS was primed to bar Mr. Essel forever from getting another I-130 approved due to his prior marriage fraud. But for reasons unexplained, USCIS reversed course and approved the I-130 petition filed by Pearl, possibly because USCIS never actually made a marriage fraud finding? I don't know, the IJ definitely did. Lucky break for Mr. Essel. Approved I-130 in hand, having already got some luck, and not physically removed from the United States, Mr. Essel asked the BIA to reopen his case and send it back to the IJ for new proceedings. While unstated, I guess two things could have happened if the BIA had indeed reopened and sent it back. Mr. Essel could have sought to readjust LPR status with a fraud waiver under INA Section 212I, or Mr. Essel could have sought that 237A1H waiver that I just mentioned, because now he had that U.S. citizen spouse. 237A1H would likely be easier to get, by the way. No hardship showing required. Just noting. But the BIA did not reopen. The motion was filed over 6 months after the BIA's decision became final, making it untimely, and so Mr. Essel was requesting that the BIA reopen proceedings using its sua sponte authority. The BIA said, "Thank you, next." It was not interested. It also denied his arguments based on the fact that the NTA that initiated proceedings was deficient, as it lacked the date, time, or place of Mr. Essel's first hearing. So that's all what's on appeal to the Eighth Circuit, which is going to be very difficult to win on. Case law makes it nearly impossible to challenge the BIA's denial of a sua sponte motion to reopen. And so, yes indeed, to the Eighth Circuit, quote, "As a threshold matter, we lack jurisdiction to review the board's refusal to grant sua sponte relief," end quote. It's just too discretionary of a thing for circuits to review, explained the Eighth Circuit. Quote, "There is a narrow exception to this rule. We may consider the issue if the board's denial presents a colorable constitutional claim," end quote. But that wasn't presented or met here to the Eighth Circuit. Then why publish the decision, Eighth? Well, likely because Mr. Essel also argued that the BIA should equitably toll the motion to reopen deadline based on Pereira and especially the Nez-Chavez decision from the Supreme Court about deficient NTAs. Mr. Essel argued that those decisions, quote, "changed the legal landscape by depriving the immigration court of jurisdiction when the notice to appear lacks the time and date of a hearing, so the BIA should reopen proceedings and grant him relief," end quote. But such a jurisdictional-based argument, at least now, is dead on arrival. The circuits are in agreement that deficient NTAs implicate a claims processing rule and not jurisdictional concerns. Mr. Essel therefore appears to have pivoted before the Eighth Circuit and raised new arguments for equitable tolling. But the Eighth Circuit declined to analyze them, finding them unexhausted. They were not argued before the BIA, and so the Eighth Circuit was not going to review them for the first time on petition for review. Doesn't foreclose the possibility of Mr. Essel filing another motion to reopen, though, and making those arguments, I guess. Just noting. But here, Mr. Essel lost his case. And that is Essel v. Garland. Burned out with admin work? Most immigration lawyers are. That's why over 90 law firm owners have chosen Staffy to help them with the legal, administrative, marketing, and client-facing work. Staffy's goal is to help immigration lawyers live a more balanced life while seeing their law firms grow and scale. And they do that by providing a service that includes top-notch bilingual virtual staff with the HR support that will alleviate the law firm owner from onboarding, continuous management, and training of their virtual teams. Concentrate on the strategic work and let the team at Staffy help you with the rest. I have a Staffy, and I couldn't be happier. Schedule a free consultation with Staffy at www.getstaffy.com. That's GETSTAFI.com and claim $500 off by using the code STAFFY2024. That's STAFI2024. These last two from the Ninth Circuit are long, so strap in. The first is Rodriguez-Hernandez v. Garland, published by the Ninth Circuit on December 27, 2023. This case is about aggravated felony crimes of violence. Mr. Rodriguez-Hernandez is from Mexico and was placed in removal proceedings in 2015. Unsure why, but his major problem was that in 2009 he was convicted of harassment in violation of Washington Revised Code 9A.46.0201. That statute appears to have a domestic component. For the offense, he received a sentence to 365 days in jail. In 2009, that statute covered a lot of things. If it covers only the use or threatened or attempted use of physical force, it's a crime of violence, and because of that 365-day term of imprisonment, would meet the aggravated felony definition at INA Section 101A43F. And that would mean that Mr. Rodriguez-Hernandez is categorically barred from cancellation of removal, which was the main form of relief that he asserted in immigration court. The IJ found that it was an aggravated felony that barred Mr. Rodriguez-Hernandez from both cancellation and asylum, and then denied withholding of removal and Convention Against Torture protection on the merits. The BIA affirmed. And so did the Ninth Circuit, although even more assertively than did the immigration judge, it seems. The IJ believed that the Washington crime was not always a crime of violence in all cases, but that it was divisible, and that Mr. Rodriguez-Hernandez's subsection of a conviction is a crime of violence. The Ninth Circuit, and the BIA for that matter, and on the other hand, held that the crime is not divisible, but that the whole thing is a crime of violence. First, divisibility. There are 4 specifically delineated and numbered subsections to this crime, something that usually indicates that the crime is, divisible into 4 separate crimes. But, quote, Washington courts have recognized that Section 9A.46.0201 is an alternative means crime, with the 4 alternatives set forth in separate subsections, end quote. Similarly, the pattern jury instructions in Washington make clear that a jury need not be unanimous as to which subsection a defendant committed, but just simply that he or she committed one of the 4. So that's very, very strong evidence for indivisibility, and it won the day here. The statute is not divisible. It's all one single crime. Couldn't be more clear, really. In the Ninth Circuit, quote, absent a requirement that the jury unanimously agree on which of the statutory alternatives a defendant committed to return a conviction, the alternatives are means, end quote. Meaning that if one of the 4 ways of committing the crime doesn't match the crime of violence definition, then Mr. Rodriguez-Hernandez doesn't have an aggravated felony crime of violence conviction, no matter what he actually did. But as I mentioned, the Ninth Circuit held that the whole thing matches the crime of violence definition. As a refresher, for immigration purposes, a state statute must require as an element the use, attempted use, or threatened use of physical force against the person or property of another to qualify as a crime of violence. The Ninth Circuit read the statute here as only criminalizing actual or threatened force against persons or property. It's a complicated statute, but at face value it does indeed appear to apply only to using force against persons or property or threatening to do so. True, one subsection criminalizes, quote, subjecting the person threatened or any other person to physical confinement or restraint, end quote. And the very smart attorneys who submitted amicus briefs argued that this could occur through deception, which requires no force at all. Trickery is not force. So too, there's a prong that criminalizes physical damage to property, which wouldn't appear to require force if, for example, we're talking about simple graffitiing. But the Ninth Circuit reminded us that a crime of violence, quote, does not require any particular degree of likelihood or probability that the force used will cause physical pain or injury, only potentiality, end quote. No pain or injury is required at all. The force used simply must be capable of doing so. More to the point, the Ninth Circuit didn't believe there was a realistic possibility that the amicus hypotheticals would be prosecuted in Washington. Again, the statute wasn't clearly overbroad to the Ninth Circuit, which means to succeed, Mr. Rodriguez-Hernandez needed to find a case in Washington where a non-force type offense was successfully prosecuted to succeed on his overbreadth argument. To the contrary, explained the Ninth Circuit, the Washington Supreme Court said in 2003 that this statute describes only a, quote, true threat, end quote, which is a, quote, statement made in a context or under such circumstances wherein a reasonable person would foresee that the statement would be interpreted as a serious expression of intention to inflict bodily harm upon or take the life of another individual, end quote. Seems forceful to the court. And the Washington Supreme Court and appellate courts have similarly held since that 2003 decision. That foreclosed any possibility to the Ninth Circuit that this crime would apply to unlawful imprisonment by deception. It wouldn't be a true threat if that occurred. Plus, there's already a crime in Washington that criminalizes unlawful imprisonment through deception, so that also undermines Mr. Rodriguez-Hernandez's argument that this Washington crime criminalizes that too. Lots of other arguments rejected too. It's a long and complicated decision. For example, the Ninth Circuit did not believe that the statute incorporated Washington mischief, which wouldn't be a crime of violence, nor did the Ninth Circuit believe that Mr. Rodriguez-Hernandez had shown that the statute applies to merely de minimis use of force, on and on and on. As to the threat of using graffiti hypothetical, well, again, the immigration crime of violence definition, as opposed to some other crime of violence definitions, applies to threats of force against property. More importantly to the Ninth, the amicus briefs didn't cite any Washington cases criminalizing graffiti under this statute. And even worse, it appears that graffiti in Washington is criminalized under a separate malicious mischief statute. So it's a crime of violence. For purposes of this decision at least, that left only Convention Against Torture Protection as the last remaining form of relief or protection for Mr. Rodriguez-Hernandez. The Ninth Circuit summarily affirmed denial of that, similar to the flaw in that Eighth Circuit decision we just discussed. Quote, Mr. Rodriguez-Hernandez testified that his family received a threatening call, warning him that he would be kidnapped when he visited Mexico. But Mr. Rodriguez-Hernandez was not able to identify who made the threats, end quote, or anything like that. He also confirmed that his family in Mexico had never been harmed. All of this meant that Mr. Rodriguez-Hernandez lost his case. But all of this long, complicated argument stuff has got me thinking. The whole thing about unlawful confinement through deception and graffiti through mischief brings up one of my favorite cases from early on in the podcast, DeGraca v. Garland out of the First Circuit on episode 91. As I read DeGraca, one of the reasons the First held that the statute there was overbroad vis-a-vis a theft aggravated felony was because the First Circuit could not find any other crime in that state that criminalized joyriding. So the First Circuit reasoned that the statute at issue in DeGraca must criminalize joyriding, because something's got to criminalize joyriding, right? What a wonderful toolbox of arguments such logic provides. Here, the Ninth Circuit applied a similar logic, but it just didn't help Mr. Rodriguez-Hernandez. Recall, there was another Washington crime or crimes that criminalized unlawful detention through deception and graffitiing. But the logic remains to be applied for your next criminal statute in a state that might not contain that overbroad analog in another criminal statute. By the way, episode 91 also contained my ode to the singer Meatloaf following his then recent passing. If you're interested, as I know you are. And that is Rodriguez-Hernandez v. Garland. Which brings us to Alcarez-Rodriguez v. Garland, published by the Ninth Circuit on December 28, 2023. We're concluding with a big old important decision from the Ninth on late-filed asylum applications. Miss Rodriguez is from Mexico, She was placed in removal proceedings in 2014 when DHS served her with a, quote, punitive notice to appear that did not specify the date or time of any subsequent removal hearings, end quote. The putative NTA alleged that Ms. Rodriguez had entered 5 years prior without authorization. DHS didn't file that NTA with an immigration court until 5 months later, and a notice of hearing followed, at which Ms. Rodriguez appeared, and Ms. Rodriguez appeared for that hearing. Eventually, removability was established, and the immigration judge ordered that Ms. Rodriguez apply for asylum and related relief and protection, at the next hearing scheduled for August 2016. But that hearing never happened. The IJ rescheduled it sua sponte, meaning on the IJ's own, 3 times, with the final hearing scheduled for December 13th, 2017. At that hearing, Ms. Rodriguez and her counsel had not prepared their asylum application, and counsel asked for more time to review medical records. The IJ obliged, scheduled a merits hearing for 11 months out, and set a deadline for the asylum application 2 months before that. Quote, the IJ told Ms. Rodriguez that if the application was not submitted by that date in September, Ms. Rodriguez ran the risk of her application being denied. End quote. The day before that September deadline, counsel filed a motion to extend the filing deadline by 15 days, explaining that counsel had had difficulty getting in touch with Ms. Rodriguez. The IJ did not rule on that motion for about 3 weeks, at which time the IJ denied the motion, vacated the merits hearing, and ordered Ms. Rodriguez removed. 24 days later, all before the previously scheduled individual hearing, Ms. Rodriguez filed a motion to reopen, submitting the asylum application with supporting evidence and evidence for reasons for the delay. But with the 30-day deadline to appeal the IJ's removal decision coming up soon, Ms. Rodriguez also filed a notice of appeal with the BIA, which likely divested the IJ of jurisdiction over the motions that Ms. Rodriguez just filed, but what choice did Ms. Rodriguez have? She then filed a new motion with the BIA, which the BIA styled as a motion to remand. What a mess. And actually, it was even worse. Quote, according to the motion, Ms. Rodriguez learned in 2015 that she had contracted HIV from her physically abusive former partner. She left that partner in approximately November 2017, just before the master calendar hearing, during which the IJ set the September 2018 deadline for the filing of her application for relief. Because of her immigration status, or lack thereof, Ms. Rodriguez was not authorized to work in the United States and was thus financially dependent on her partner. She became homeless without her partner's support, and her phone was eventually disconnected. She therefore received no communication from her attorney until September 5, 2018, when her ex-partner's mother hand-delivered a letter that had been sent to Ms. Rodriguez's former residence. During this time, moreover, Ms. Rodriguez was unable to access medical documents and criminal records relevant to her asylum application because she lacked funds to pay the storage facility where those documents were kept. End quote. And really, the explanation just goes on like that. You get the gist. In addition to being suicidal, quote, she was also immunocompromised because of her HIV and had gone to the emergency room 3 times in September 2018, the very month when her relief application had been due, end quote. 2 years and 9 months later, the BIA denied the motion and dismissed the appeal. Quote, in so doing, the BIA did no more than cursorily consider the merits of the motion to remand, end quote. Ms. Rodriguez petitioned for review to the Ninth Circuit. Fortunately for her, or through excellent lawyering, the Ninth Circuit saw her petition for review not as a request to review the BIA's denial of a sua sponte motion to reopen, or of the IJ's decision to deem her asylum application abandoned. Rather, the Ninth Circuit read her petition as requesting simply that the Ninth Circuit, quote, remand her case to the BIA so that it might properly consider her motion to remand, end quote. Ms. Rodriguez was pointing to the newly discovered evidence and reasons given for excusing the filing deadline. The Ninth Circuit obliged. Similar standard to a motion to reopen review, though, even though the Ninth Circuit sees itself as reviewing denial of a motion to remand and a request for remand to the BIA at that. And here's a quote, a non-citizen may move to reopen or to remand for the purpose of submitting an application for relief even if the IJ did not previously hold a merits hearing on that claim, end quote. One of the main prongs of succeeding on such a motion is establishing prima facie eligibility for the relief sought, which recent Ninth Circuit precedent tells us is a fairly low standard. Then, in addition to submitting the relief application and other things, the non-citizen must submit, quote, evidence that was material and was not available and could not have been discovered or presented at the time of her application deadline, end quote. Ms. Rodriguez argued that her medical and criminal history was not available at the time of the asylum filing deadline, and that it was material to her asylum claim. The Ninth Circuit agreed. Even if some of the evidence technically existed at the time of that deadline, quote, it is not sufficient that the evidence physically existed in the world at large. Rather, the evidence must have been reasonably available to the petitioner, end quote. That's a heck of a quote and a heck of a standard for motions to reopen. Write it down. Quote, Ms. Rodriguez also argued that her evidentiary submission demonstrated her prima facie eligibility for the relief that she sought because of her status as an HIV-positive transgender woman and rape survivor, a conclusion that in light of this court's case law appears eminently reasonable, end quote. Ninth Circuit string cite afterwards for your citing pleasure. In light of all this, the BIA's cursory denial cannot stand. Perhaps realizing that the BIA might not be keen to grant a remand even on the Ninth Circuit's remand here, the Ninth, for a, quote, the benefit of the BIA, end quote, reiterates to all of us that, quote, the availability of evidence at some point prior to a petitioner's filing deadline does not mean that such evidence is forever available to the petitioner for purposes of a motion to reopen or remand, end quote. The standard that must be applied in situations like this is one that analyzes whether the evidence is, quote, reasonably available, end quote. Here, Ms. Rodriguez was gathering evidence which became unavailable notwithstanding its existence when her abusive partner made her homeless and she had medical emergencies and all of that. Not only that, explained the Ninth Circuit, but there's the BIA decision in matter of RCR, episode 19. If I recall, I did not believe that decision the most non-citizen friendly at the time. But that's the beauty of case law, right? To the Ninth Circuit, matter of RCR also stands for the proposition that, quote, reconsideration or reopening by the immigration judge would likely also be appropriate where the non-citizen has satisfied the additional requirement of providing good cause for missing the deadline, end quote. How about that reading of matter of RCR? Just to get it out of the way, Judge Forrest disagrees with this RCR analysis in concurrence, but the majority's interpretation of that BIA decision won the day. Quote, matter of RCR's good cause standard is fully consistent with the principle articulated by our sister circuits, that it is a matter of concern when an IJ's strict adherence to the established time limit prevents a petitioner from presenting his case, end quote. Anyway, again to the Ninth Circuit, the BIA kind of gaslit Ms. Rodriguez in its decision denying her motion, so the BIA needs to do it again. Seems like we're teed up for a big BIA decision on remand, actually, as the Ninth Circuit is expressly remanding for the BIA to, quote, articulate the factors that determine whether good cause exists to extend a filing deadline, end quote. And then the Ninth Circuit cited to its own precedent for guidance on what standard it thinks the BIA should adopt. Love it. So congratulations, Ms. Rodriguez. Godspeed with everything that lies ahead for you. And congratulations to Mariana Elhana from San Diego for petitioner. Also, no need to wait for the BIA's decision on remand for some important precedent when you've got this. Gonna just leave this quote here as it's pretty expansive and, well, deserves its own section. Quote, in sum, non-citizens in removal proceedings must be afforded the fundamental fairness that is guaranteed by the Fifth Amendment. We thus find eminently reasonable the BIA's waiver of the general prohibition against considering discretionary applications where 1. The application is for relief based on credible fears of persecution, and 2. The non-citizen has established good cause for failing to timely file. End quote. Restated, IJs and the BIA need to accept untimely asylum applications where the non-citizen establishes good cause for missing the filing deadline. That's how I read the quote anyway. How about you? And that is Alcarez Rodriguez v. Garland. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzelli & Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview, that's IMM Review. I'll be back next Monday for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.